they did a little roasting of Kavanaugh because in their paper and their motion for class-wide certification and their motion for, quote, grant or deny the functional equivalent of a universal injunction, for example, by granting or denying a preliminary injunction to a putative national class under Rule 23b2, Rule 23b2 class certification for injunctive relief. Thus, the parents of children covered by the citizenship order are well advised to follow my lead, Justice Sotomayor said.
The Supreme Court thought they shut down nationwide injunctions. Spoiler alert, they just opened the door to something even bigger. Class actions are about to steal the spotlight in a way that's making legal strategists look like geniuses. What's their next move? Let's find out. Before we move on, I'd like to ask you a small favor. If you appreciate this content, please take a second to like this video and subscribe to the channel. Over 98% of you watch the videos without subscribing. It costs you nothing, but it makes a huge difference to us. So, did you click the subscribe button? Great, thank you so much. Now, back to the video. The Supreme Court thought it had figured out how to rein in lower courts and control the chaos of nationwide injunctions. Their plan? Limit the ability of federal judges to issue sweeping rulings that could block government actions nationwide. Sounded neat and tidy, right? But as it turns out, their move played out more like a game of chess where, halfway through, someone realized they just handed the opponent the queen.
Here's what they said on page 2 of their motion for class-wide certification. Justice Kavanaugh's concurring opinion confirms that district courts may, and Justice Sotomayor's dissenting opinion notes that the majority leaves untouched one important tool to provide broad relief to individuals subject to lawless government conduct. And that's what they've done. Now, let me break it down for you. That's a lot of words. Let's do a legal AF TED talk right now about class certification.
Class actions. Yeah, those lawsuits where one case can affect thousands or even millions of people became the unexpected power play. By trying to restrict legal challenges, the court didn't stop the game. They just changed the rules, and now things are about to get messy. At the heart of all this is the Supreme Court's decision to clip the wings of trial courts. The rationale was simple enough. Lower courts had gotten a little too fond of issuing nationwide injunctions, those broad rulings that could block controversial policies like immigration bans or limits on voting rights. The Supreme Court believed these injunctions gave too much power to individual judges. Justice Kavanaugh even chimed in, saying that these sweeping rulings were legally dubious and way outside what district judges should be doing. It was supposed to restore some order, cut down on forum shopping, and stop plaintiffs from running to whatever court they thought would rule in their favor. But the problem with plugging one hole is sometimes you spring another leak. Enter Justice Sonia Sotomayor. In her dissent, she basically handed out a DIY guide for future challengers. She didn't mince words. If the Supreme Court was going to make nationwide injunctions harder to get, then challengers should just take a different route. Class actions. She pointed to Rule 23b2, the regulation buried in the federal rules of civil procedure that governs class certification for cases seeking broad relief. It was like she was saying, fine, you took away one tool, but here's another one just as sharp, maybe sharper. So what exactly is a class action? In simple terms, it's a way to bundle a lot of related claims into one big lawsuit. Instead of hundreds or thousands of separate cases clogging up the courts, you get one case that represents all the people in the same boat. It's efficient, sure, but there's a much bigger advantage here. You can take on massive government actions, like that executive order trying to challenge birthright citizenship, with just a few representatives standing in for a much larger group of people. And thanks to Sotomayor's roadmap, legal teams wasted no time tapping into this strategy. As soon as the Supreme Court's ruling hit the books, attorneys were ready to act. Hours after the decision, class actions were filed, aiming directly at Trump's executive order on birthright citizenship. These lawyers were prepped like they'd been waiting for this exact moment to pounce. They didn't just file for class certification, they also sought temporary restraining orders at lightning speed, hoping to block the executive order before it could cause harm. The game had shifted, and the new playbook was unfolding in real time. Here's why this is ironic. By trying to curb legal challenges, the Supreme Court accidentally opened the door to an even bigger one. In a class action, a single judge's ruling doesn't just apply to one plaintiff, it can impact everyone in the certified group. That's the kicker. It's like a sneaky workaround to achieve nationwide relief without explicitly asking for it. One ruling, one courtroom, but the fallout. National. The very thing the Supreme Court was trying to avoid with the limits on injunctions just got a brand new delivery system. The stakes are huge in this game of legal chess. Immigration advocates know that class actions may be their best bet to fight back against policies that threaten birthright citizenship. Picture this: babies born in different states, some with citizenship, some without, all depending on whether their parents' immigration status lined up with Trump's executive order. More than just a legal issue, it's a human one too. And these class actions aren't just about winning a case in court, they're about creating a structural change that outlasts any single presidency. But how do these legal teams make sure class actions work? They have to get their group certified first, and that isn't a walk in the park. Certification means proving that the group members have enough in common to be treated as a single entity in the eyes of the law. This is where the Trump administration will likely put up a big fight, hoping to block the certification process. And they've got good reason. If a class action succeeds, it could set a legal precedent, effectively giving a judge's ruling the kind of reach that rivals, if not fully replaces, a nationwide injunction. Now, here's where things start to heat up. This isn't just about stopping one executive order. Class actions have the potential to ripple far beyond the courtroom. If one judge rules in favor of a class, that decision has tentacles that spread into broader policies, affecting countless lives. What started as a supposed limitation on lower courts might just be the Supreme Court's own creation spiraling out of control. Justice Kavanaugh and his friends on the bench might have thought they were playing checkmate, but it looks like this chess game is far from over. That's the nightmare scenario here. Toss a certified class action into the mix, and suddenly, instead of playing defense on one case at a time, they're up against a tidal wave of legal challenges. One decision can grow legs and affect everyone who fits into that group. It's no wonder Justice Sotomayor practically handed out directions for it. Let's break this down. Class actions are governed by Rule 23 of the Federal Rules of Civil Procedure. Sounds like a bureaucratic mouthful, but it's simple at its core. The whole idea is to consolidate similar lawsuits into one mega case when the plaintiffs share a common injury caused by the same policy or action. Imagine dozens, hundreds, even thousands of people bringing the same complaint to court separately. Instead of that chaos, Rule 23 lets them come together, represented by a handful of people, reducing repetition and saving everyone time, except maybe the defendant, who suddenly has much bigger problems to worry about. To get a class action moving, lawyers first have to convince a judge to certify the class. That's where things get tricky. Certification means proving that the group has enough in common to act as a single entity in court. It's like saying everyone in the room isn't just randomly upset, they're all sitting under the same hole in the roof. For immigration cases, this could mean proving that thousands of parents affected by Trump's birthright citizenship policy are grappling with identical legal barriers. If the group gets certified, the game changes entirely. One ruling on their claims will apply across the board. If they win, the relief is massive. But if they lose, it's equally disastrous. The Trump administration, of course, will do anything to block certification. They know what's at stake. If even one of these cases gets certified, that's a potential precedent waiting to strike. And precedent doesn't just disappear, it sticks. Imagine a judge ruling that Trump's executive order violates constitutional protections or is flat out illegal. That's not just bad news for Trump now, it's a blow to his policy goals going forward. You can almost hear his lawyers scrambling to file paperwork to stop it. If you think this is all theoretical, think again. There's already a playbook for how this works. Remember the case involving deported individuals in El Salvador? A judge certified a class of 250 people who had been sent back without being given their due process rights. That class action led to a ruling that applied to all 250 members, stopping the deportations cold. It didn't matter if the plaintiffs lived in Texas, Maryland, or anywhere else in the country. When the class got its ruling, it acted like a nationwide injunction without technically being one. You could practically hear Justice Kavanaugh groaning all the way from the bench. This precedent didn't escape the notice of lawyers strategizing against Trump's latest birthright citizenship plans. Hours, yes, hours after the Supreme Court ruled against nationwide injunctions, a class action was already filed. Parents affected by the executive order didn't wait around to see what would happen. They immediately sought temporary restraining orders while pushing for class certification. It's a legal 1-2 punch. The restraining order is the quick solution, stopping policies from taking effect before they cause damage. Meanwhile, the class action is the long game, laying the groundwork for a decision that could block harmful policies for good. But here's the part you can't ignore. Time is everything. Lawyers have to race against the clock because while they're filing paperwork and waiting for decisions, the Trump administration isn't exactly sending out invites to talk this over. They're enforcing policies, and those policies could start affecting families before the courts have even weighed in. That's why temporary restraining orders are such a crucial tool here. They buy time to let the legal arguments play out before people actually suffer the consequences. They'll ripple out to anyone who could face the same policies down the line. It's a legal domino effect, and the stakes couldn't be higher. Here's the irony though. The Supreme Court tried to stamp out nationwide injunctions to stop courts from wielding too much power. Instead, they've indirectly created a system where class actions do almost the same thing with better optics. A nationwide injunction, that's a judge taking a bold stand, but a certified class action, that's just the court following the rules. The result? Relief that's every bit as wide-reaching, but harder to challenge on procedural grounds. It's checkmate, only with a side of clever wordplay. But this is just the opening act. If you think Trump's lawyers are stressed now, wait until these cases start hitting appellate courts, or even the Supreme Court again. The legal chess game is far from over. Who gets the last word here? The court that set the rules, or the lawyers rewriting them in real time? The class certification is just the opening strategy in what's shaping up to be a legal chess match for the ages. Once that's done, the lawsuits start climbing the legal food chain, heading straight for the Fourth Circuit Court of Appeals. Now, if you're unfamiliar with the Fourth Circuit, let's just say it isn't exactly the Trump administration's favorite. This is a court that has, on more than one occasion, ruled against policies cooked up by Trump's team. But don't get comfortable, whatever the result here, the losing side won't stop there. An emergency application to the Supreme Court is pretty much a given, and if you thought the stakes were already high, just wait. The final decisions could land right in the middle of the Supreme Court's summer docket. Nothing like a little beach reading involving the Constitution and the future of birthright citizenship. Both sides are playing an incredibly risky game. If the Trump administration loses, it's not just their policy on the line. The decision could set a sweeping legal precedent that outlasts Trump and ties the hands of future administrations. Think about it. If a class action succeeds in protecting birthright citizenship, that's a clear message that executive orders can't just sidestep constitutional rights whenever it's politically convenient. On the flip side, if the plaintiffs lose, it gives the administration a green light to double down on executive overreach. Policies like rolling back rights or bypassing Congress could become a lot harder to challenge in court. It's not just one policy at stake, it's the balance of power. Behind this fight are two unstoppable legal organizations that have made a name for being as fast as they are strategic. On one side is the Asylum Seeker Advocacy Project, a group that's practically built for this kind of challenge. These are the folks who don't wait for policies to wreck lives before stepping in. They file lawsuits before the ink on an executive order is even dry. Then there's the Institute for Constitutional Advocacy and Protection out of Georgetown. A long name, yes, but their track record backs it up. They've got a knack for crafting airtight arguments in cases where constitutional rights are under siege. Together, these groups are a nightmare combo for the Trump administration. They know how to read between the legal lines, adapt their arguments, and leverage opportunities. Justice Sotomayor's dissent wasn't just an opinion to them, it was a gift wrapped in footnotes and precedent. And here's the kicker. The Supreme Court might have to sit there and eat its own logic. Their decision to limit injunctions was supposed to prevent this level of impact, but instead, they created the perfect environment for class actions to flourish. The irony is almost poetic. But this isn't just a straight path to victory for the plaintiffs. Fast-tracking the case to the Supreme Court throws everything into uncertainty. The court that set the rules might have to revisit them. And let's be honest, this isn't exactly a group known for humility. Will they double down to protect their prior ruling? Or will they acknowledge that their own reasoning opened up a legal Pandora's box? Either way, the stakes are enormous. Babies born in states enforcing this executive order could remain in limbo. Their citizenship status is dangling by a thread while the court deliberates. That's not just a legal issue, it's a human one. Every day that passes affects real families. No matter how it plays out though, one thing's already clear. The legal teams fighting against this executive order know how to use the system to their advantage. The Supreme Court's restrictions were supposed to corner them, but instead they found a way to turn those limitations into an opportunity. Class actions have become a tool more powerful and potentially more dangerous for the administration than injunctions ever were. It's not just about winning, it's about flipping legal setbacks into strategies. And that brings us to the big question. What does all of this mean for the future? Birthright citizenship isn't just on trial here. This case, however it resolves, sets the tone for how legal challenges to executive power power will play out in the years ahead. So, where does this chess match go next? Because if the legal strategy so far is any indication, these lawyers aren't about to fold. The Supreme Court tried to clip the wings of judges, but they ended up handing lawyers a new set of tools instead. By limiting nationwide injunctions, they inadvertently fueled smarter, sharper legal strategies like class actions, proving the fight for birthright citizenship is far from over. Groups like the Asylum Seeker Advocacy Project adapted quickly, showing just how resilient legal advocates can be when power gets too bold. These battles aren't just procedural, they're shaping the boundaries of constitutional rights right now. So stay informed, because this isn't just about laws, it's about who gets to decide the future of America.